Oh, you're right.
I've never seen any notes told. Yeah. You're seeing the name?
Right, whatever. Third. I don't know. I told her to do the commercial and she does. I'm thinking very young and old. Yeah.
Yes, seafood.
All rise. The Honorable Court of Appeals for the 7th District of Texas is now in session.
Please be seated. We welcome you to the change hands here. The May 7th, 2025 settings, the 7th Court of Appeals sitting here in Amarillo. We thank the attorneys for coming up, making the drives from the respective places. I think even Joey had to drive too, didn't she? Well, but thank you for coming up. We'll go on and call the docket and hear your announcements. I know some of you have argued here before, so you know our admonishments, but you've received a letter talking about the times allotted to both sides. And of course, the appellants have a 5-minute rebuttal already built in, so you don't have to ask to reserve time or anything like that. So with that said, the first case that we have this morning is 07-24-00302 CV, State of Texas versus Jimmy Glen Riemer and others for the appellants.
Mark Osborne, kids later for the state of Texas.
Mr. Osborne, you doing all the argument, or is Mr. Slavin going to tag in, or how you guys? I'm sorry?
I will be.
Okay. Very good. And for the appellees?
Bill Warren, now here with Elizabeth Thomas, Jody Sheets, and I will be doing the argument.
Very good. You saved me from asking that question. Very good. Mr. Osborne?
Thank you, Your Honor. May it please the court, counsel. Good morning, Your Honors. I'm Mark Osborne. I represent the state of Texas in this appeal, which involves takings claims regarding certain mineral interest in what the parties have come to call the disputed area of the Canadian River. One of the exhibits that we gave you, let me tell you, I have very bad eyesight. I do not expect you. I do not expect you to be able to see this now, but it's in our oral arguments. But I just want to explain this for some nomenclature. The disputed area, the shaded area, is what within the state's lease to Huber. When you look at this as Defendant's Exhibit 6. The disputed area runs from the Sanford Dam to Highway 136, this red vertical line. So this is the disputed area that's shaded. And in order to have some way to consistently talk about the land that's involved, there are sections above and below, north and south of the Canadian riverbed. So what we did was we took within the disputed area, we drew lines that are just continuing the vertical lines of the sections down to the center line, which created what we call tracks. And these tracks, we divided them between what's north of the center line of the river and south, and they're numbered in 1, 2, 3, 4, going from west to east from the dam to the highway. And then on the south side of the center line, it's S1, 2, 3, 4. So that's when you hear me talk about tracks, I'm talking about those specific pieces that we were able to identify, and then we could determine, which plaintiffs had interest in which tracks, that sort of thing. There are 17 plaintiffs, and they have interest in, and they're varied, but they have interest in 18 different of the tracks that are in that disputed area. So there are 3 reasons why the state suggests that this on appeal, there should be a render of a take-nothing judgment. The first reason is that from 1965 on, and that's the date of the completion of the Sanford Dam, within the disputed area, there was no area leased by the state to Huber. The second reason is because the plaintiff's claims are barred by the applicable 10-year statute of limitations. And the third reason is that the plaintiffs did not own any of the mineral interests that were involved in this case in 1982, in January 28, 1982, when the trial court found that the taking occurred. And finally, there's one other consideration, and that is that the trial court's determination of damages should not be disturbed on appeal because the testimony of Mr. Tor Melling, the plaintiff's damage expert, was not credible. So let's look first at what the state leased to Huber. These leases began in the 1920s and they were renewed every 10 years. The relevant years for this case are 1957, 1967, and 1977, and those are exhibits, defendants exhibits 34, 33, 34, and 35.
All of the leases for every 10-year period are part of the record?
Yes, yes. In fact, the entire set is in the record, but these are the three that are relevant to the time period involved in this case. So in 1965, the Sanford Dam was completed. From that point on, no water flowed past the Sanford Dam in the disputed area. In other words, from west to east in the Canadian River. The other important date is January 28, 1982. That's the date the trial court found the taking occurred. That's when the Shine survey was accepted by the GLO.
Just curiously, yeah, one of the, of course, without a flowing navigable stream, boundary shifts, state loses its ownership interests, etc. And I guess that's the reliction thing.
Right.
Over what period of time does that occur? Does it occur as the water shrinks, or is it pretty much when there's no more water and it dries up, or as long as there's some marshy area, or?
So that's actually that's a great question. Let me tell you why it's critical here, because it relates to what are the boundaries of the river. Okay, this court decided that issue in 1953 in Johnson versus Phillips Petroleum.
I don't think any of us were born in 53, though some of us were close.
I was relatively close myself, but not yet. So what happened in that case, it involved a dispute between one of the section owners adjacent to the Canadian River and its lessee, but also a party to that dispute was the state and Huber, and there was a dispute over the boundaries of the lease. And what this court found was that the boundaries of the Canadian River are the banks of the river. And the banks of the river are determined by finding the gradient boundaries. And so, and I'm going to get to answer your question in just 1 second, but how that relates to this is from those leases from 57, 67, and 77, the leases began to provide, because they were taking into account that the decision in the Johnson case, the leases provided that what's leased is the riverbed of the Canadian River in accordance with the decision in the Johnson versus Phillips Petroleum case. So it's clear now that what's being leased is whatever the boundaries of the river are, the riverbed, which is where the gradient boundaries are. And that's where the Sanford Dam comes in. Once the Sanford Dam was completed, we don't know exactly how quickly the water stopped flowing, but it was clearly within that year. There was no more water. And from 1965, it was impossible to identify gradient boundaries for the river.
How do we know that from the record?
Because there's testimony in the record of different people, surveyors and things, saying we can't find gradient boundaries. In fact, the Shine survey, what he was doing was saying, let me go back and locate the gradient boundaries before the river stopped flowing. That he acknowledged that's what he was doing. He was not finding present gradient boundaries.
Define gradient boundaries.
Okay, so that's a great question, and I had to make sure I could answer that today. So a gradient boundary is you take the high point of the river flow, and we're going to talk about, say, the course of a year. At some point, the river flow is at its height, as long as it's not flooding. So you take that high point, you take the low point, which presumably is at the opposite time of the year when the river's at its lowest, and you find the median between those two, and that's the gradient boundary of the river. When you don't have a river, you can't locate that. So, and that's what the trial court found in its findings of fact, that in 1965, the river collapsed to the center line because there were no gradient boundaries. That's one of the findings of fact.
When this court wrote the Johnson opinion in 1953, did it use the gradient boundary definition, or did it simply define it?
It simply said gradient boundaries, but it did refer to other cases and where that had been defined. It's a surveying term.
The reason I'm asking, if the lease adopts the Johnson opinion or says it's in conformity with the Johnson opinion, and the Johnson opinion refers to something other than the gradient boundary as its definition, is that an agreement by the parties to define it differently? If Johnson differs from what we view now as the gradient boundary definition.
Say yes for this reason. It wasn't so much that this court decided it. It wasn't like it's some kind of like a boundary commission or something.
Right.
The court was determining the law. And so what the parties were saying in the lease is they're really saying we're following the law.
Yeah, I guess my question's slightly different than that.
Okay.
My question is more, when parties enter into a contract with one another, they frequently will refer to extrinsic documents for defining how conduct is measured, et cetera. Is the Johnson opinion simply an extrinsic document that tries to define how those are defined?
I think it's more than that in this case, because, for example, you could say we're going to refer to a certain survey or a plat. And I think that would be the example of what you're saying. I think here what we're saying is we're following the law, but this court decision is where the law is set out. So I think it's a little more than just referring to a document. So that sets out the boundaries. So then you have the center line, the river collapses to the center line in 1965. So then what's leased in the disputed area? There's nothing leased. And if nothing was leased, then nothing could be taken. Because the plaintiff's claim, it's not solely dependent on it, but it hinges on the existence of whatever was being leased by the state to Huber. So from 1965 on, if there's nothing leased, then there could be nothing taken. So what happened? Two issues about that. One is, what's the significance of the Shine survey? And the plain simple answer is none. The Shine survey was an attempt to identify the boundaries, but it didn't do it. It didn't do it correctly. It doesn't by law set anything, so it had no consequence. And the other question is, well, what happened after 1965? Huber continued to drill and to produce oil and gas. So what's the consequence of that? And the consequence is that Huber adversely possessed the mineral interest because it wasn't doing it under its lease. That's in line with the Supreme Court's holding in natural gas pipeline versus pool, where you had virtually an identical situation. It was discriminated because of inactivity. But then after that termination, the lessee continued to drill and produce later and continued to pay royalties to the lessor.
The state continued to receive royalties here.
Exactly the same facts.
So
and what the Supreme Court said was that when you did that, the lessee had adversely possessed the mineral interest, despite the fact that the lessee continued to pay royalty interest. That's exactly what happened here. Huber was sued as a defendant. The plaintiffs, Huber asserted the claim that it had adversely possessed the mineral interest. The plaintiffs settled with Huber and got paid compensation for their claims against Huber. So I think that's the first reason, is there was nothing leased. The second reason is the limitations period ran. The applicable limitations period in this case is a 10-year limitations. This is a takings case involving real property. And in Brazos River Authority versus Graham in 1961, the Texas Supreme Court said there's a 10-year limitations period that is applicable to takings claims involving real property. That 10-year limitations is borrowed from an adverse possession limitations period. That opinion has been followed in the last 65 years by 5 other courts of appeals, and no courts of appeals have held otherwise. But in this case, the trial court applied a 25-year limitations period. The question is, what should the limitations period be? And I think for public policy reasons, there should be a single limitations period for takings claims involving real property. And that should be,
trial court apply the 25-year?
because it did look at there are 5 different limitations periods applicable for adverse possession limitations. And it looked at those and decided to apply the 25-year period.
Did it explain why?
No, in fact, all the summary judgment order simply says is that the claim of the state that the plaintiff's claims are barred by limitation is denied.
Were the leases between the state and Huber, Were they recorded of record someplace?
I actually do not know the answer to that question.
Okay.
If I'm not mistaken, the 25-year limitations period was amended in the early eighties. Which one applies? The one before the amendment or the one after the amendment?
So, Your Honor, I actually don't think any of them apply. Either one applies.
Okay,
Because I think, again, this is not an adverse possession case. It's a takings case. And you should have one limitations that applies to all real property takings claims in Texas. And it makes sense to use the 10-year. That's what the Supreme Court has taught. And so far, all the courts of appeals that have looked at it have followed it. And if you look at the reasons, the elements are not the same for adverse possession. The parties are not required to put on proof of the elements of adverse possession, and there's no perfect mapping from adverse possession to taking. So it doesn't really make sense to go and say, we're going to have 5 different limitations periods for real property takings claims and then see which one maps over. But even if you were to do that, the 10-year limitations period would map over. And that's because if you look at each individual plaintiff's claim, no plaintiff had a claim for more than 100 acres of mineral interest being taken. So each plaintiff had a claim less than the 160 acres, which is what you use when you apply the 10-year limitations period. And also the 10-year limitations applies when there's a title instrument. And here you have a title instrument. That's the state's lease to Huber. A lease of mineral interest is a conveyance of title to those mineral interests in the state of Texas. That's also in the natural gas.
that's the same title instrument that would be utilized to satisfy the 25-year provision.
Yes, I mean, it will satisfy a number of them. And again, that's part of the problem is you go back through and look at, and how do you decide, are we going to pick all 5 of these are applicable? We have to determine the right one in each takings claims.
That's what I'm trying
I
to.
think in public
trying to
policy
figure out.
reasons not to do that.
But I'm trying to figure out why the trial court chose 25 years, and I was looking at statute of limitations, a 25-year statute of limitations, and it says 25 years when asserted against somebody,
I think,
another who holds the property in good
Yes.
faith under a deed or other instrument purporting to convey the property.
another reason, Your Honor, is
Well, would the deed or other instrument purporting to convey the property, would that be a deed to the state, since the state's only party left now?
I'm sorry, a deed to the state.
The 25-year limitation period, correct? It says a person, regardless of whether the person is or has been under a legal disability, may not maintain an action for the recovery of the real property held for 25 years before commencement of the action, peaceable and adverse possession by another, and I'm assuming the defendant is by another,
Right.
and if I'm wrong, let me know, by another who holds the property in good faith and under a deed or other instrument purporting to convey the property. Does that mean the state has to be claiming under a deed or other instrument?
Yes, and I don't think that fits.
Is the lease that deed or other instrument?
It's going the other direction. It's a grant from the state to the lessee, to Huber. It's
Okay,
a deed to Huber, not a deed to the state.
is there any authority you've encountered that talks about the right of the state to own the river of a navigable river, the riverbed of a navigable river, commensurate or the same thing as a deed or?
No. I mean, it's in the state constitution.
Okay.
I do think there's another reason though, and the reason the trial court may have also thought it was okay to apply the 25-year statute was because at the time, the parties did not know the extent of each plaintiff's claim. There was no evidence in the summary judgment about how much net mineral interest each plaintiff claimed. So nobody knew at that time that each plaintiff was actually, in fact, claiming less than 100 acres of mineral interest. So they didn't know that you had that limitation that would fit into 16.026. Let me address very quickly the last reason why this court should reverse and render, and that is who can make a takings claim. The party that can make a takings claim is the owner of the property that's taken. The taking occurred in January 28, 1982. In 1965, according to findings of facts number 2 and 4, the Sanford Dam was completed. The river bed collapsed to the center line of the river. And what the trial court held was the parties who owned the sections to the north and south, the owners of those mineral interests acquired the mineral interest in each of the tracts. to
Can I
the
stop you for just a minute? You said the taking occurred in 1982.
two.
Is that, I thought your argument previously was that it occurred in 1965, so I'm trying
I'm
to.
going to focus, I do believe there are reasons for that, and those are set out in the brief, but we're happy with the date, to use that date of 1982.
Your argument is that whether whether the
Yeah.
taking occurred in 65 or in 82,
it doesn't
10-year
matter.
period
Right.
passed
Yes,
but I guess what you're really arguing here is that this is a claim that doesn't run with the land.
actually, it's more than that, Your Honor. This is a little different focus, because what happened was when, the owners of the mineral interest in the sections in 1965 became the owners of the mineral interest in the tracts. Okay. Finding of fact number 7 says that in January of 1982, all of those mineral interest in the tracts were under lease. So the owners of the mineral interest in the tracts were the lessees, oil and gas producing companies. Those were the parties who were entitled to bring a takings claim. Plaintiffs do not claim any interest. They don't claim to be those lessees. They are not the oil and gas leasing companies, and they don't have any claim whatsoever. They've never made the claim, and there's no evidence in the record to show that they acquired that claim from those lessees, from those oil and gas companies. That's who actually had the takings claim, if there was one to bring in 1982. They don't have that, and that's a standing issue. They cannot bring a takings claim. So for that reason, the court should reverse and render. Unless you have other questions, I'm going to jump over just for a moment to the issue of damages.
You got a minute left.
Okay, I'll be quick, and I may come back to this, Your Honor. When you look at the damage award, the trial judge did the very best he could to determine what was the appropriate damages to award based on the credible evidence that was presented. The measure of damages in a taking case is what is adequate compensation. In a real property takings case, that is normally determined by finding what is the difference in the fair market value of the property taken immediately before and after the taking. But in this case, there was no credible evidence presented of the fair market value of the property that was taken. The only credible evidence that was presented was the evidence of what the state received from Huber under the entire state lease for the period from 1982 through 2022. And the reason that's the only credible evidence is the only other evidence offered was Mr. Melling's, he was the plaintiff's damage expert, but the court found his testimony was not credible. As the trial judge said, it was just too far out of left field. And I'll stop there, Your Honor. Thank you.
Thank you, counsel. Again, you do have 5 minutes as well.
Thank you.
May it please the court. I'd like to respond to Mr. Osborne's points, and also maybe spend a little bit more time on the damages issue if time permits and questions permit. With respect to the 1965-1982 dichotomy, I think it's important to actually look at the leases that Mr. Osborne referred to. It is true in 1957 and 1967, what was leased under the leases from the leases to Huber was the riverbed as it now exists. In 1977, though, and we provided a timeline to the court, I think it's the tab A to the handouts that we have. It refers back to that 1977 lease, and the 1977 lease changes. It says releasing the riverbed, but also refers to it that it includes the boundaries in a survey. And the survey, of course, is the Morris Browning survey from the 1950s, which, according to the trial court's, or at least the state's position before the trial court, was actually wider than the Shine survey. So now they're going from the riverbed as it now exists to a determinable wide piece of property. And remember what happened between 1967 and 1977 that caused that change. In 1971, the Attorney General issued an opinion that says, well, it may be that a riverbed, once there is a dam or some other artificial creation that affects its flow, that the state's ownership could go back to the historical riverbed before the dam existed. In 1977, then after that, what do? they start referring back to those pre-dam surveys to say, this is what's actually being leased to Huber. Now, in 1975, to put it in further context, you have the legislature who came out and said, we don't know where the riverbed is. It is uncertain. It is confusion. And GLO, you need to do something to correct that misunderstanding, to make what is uncertain certain. And so what do? They directed the GLO to do a gradient boundary survey, which Johnson acknowledged back from model versus void, back from Oklahoma versus Texas, is a proper way to determine a bank's boundary. In 1980, according to the evidence, they retained Darrell Shine. And in 1982, Shine comes out with his survey showing that the riverbed is over 1,700 acres, if memory serves. The state then takes that survey and tells its lessee, here's the riverbed. And what do we know from the evidence after that? Plaintiff's Exhibit 55. Shine, or Huber, sends its letter to the state saying, now that we've got this gradient boundary survey, we're going to begin our aggressive drilling campaign. We're going to drill offset wells. We're going to pursue this drilling campaign that had not previously pursued up and down where the Shine survey is. And to put that into further context, in 1953, I believe it's Plaintiff's Exhibit 12, Huber had previously said, we're not going to drill anywhere outside of the water-washed areas of the riverbed. That's the safest place that we can go. And until you give us a gradient boundary survey, they said this in 1953, the same year Johnson was issued, we're not going to drill outside of that. So jump forward to 1982. Here's the Shine survey, Huber. It's a gradient boundary survey that you've been asking for. And how does Huber respond? We're going to begin our active drilling campaign. Now, why is that all important? Because of the Sawyer Trust case from the Texas Supreme Court, which said there's two things that you need to have a taking. One, you need a claim of ownership by the state, which is exactly what the Shine survey was. They took the Shine survey and said, we now own all this riverbed. It is proven by our gradient boundary survey.
Why would it not go back to at least 1977? 77 adopts the 1953 survey, which, if my understanding is correct, is wider than the Shine survey. It appears there that the state is saying, under the authority, you can drill within anywhere of this area. Why is that not the right date?
There's two responses there, Your Honor. The first one is the second part of the Sawyer case. It says you need to have the claim, and then you have to have the taking of minerals from it. There's nothing in the evidence that shows there was a taking of minerals between 1977 and 1982. The second reason is, I mean, candidly, there's no issue that was raised before the trial court that 1977 was the appropriate date. It's either 65 or 82. But with going back to that, though, with the point I was making a minute ago about the lack of evidence of production, the only evidence in the record was that this question was asked of the state's witness, Susan Drawn. But were there wells that had been drilled by 1982? And she said, yes, there were 21. She later testified that 14 of those were plugged, and the ones that were drilled, we don't know when they were drilled.
The state argued just a minute ago that during that same time period in 1982, none of your clients held their mineral interests in the land, that they had all been leased out to other companies. How does that not undermine your client's position, because they would not have been able to take anyway?
Two responses. The first one being, there's no evidence that any lease would have included this area. And I'm going to go by way of example. For the lease to the state, to Huber, how does it describe the area under lease? It defines it by the existence of, I believe it was the Morris Browning sketch. Okay, if there was a budding, and the finding by the court was that the adjoining land was under lease. How do we know what the limits of those leases were? Were they to the Morris Browning survey? Were they by meets and bounds? The state offered not one lease into the evidence. The only evidence that the abutting land was under lease was testimony from some of the witnesses that, yeah, I kind of remember receiving royalty payments back then, but there's not one lease in evidence that shows what its terms were. What was the extent of it? Was there any sort of clause that upon condemnation it terminates? And the second reason, Your Honor, is if you look at, you cited the court to the case Brazos River Authority versus Gillum. It's a 1968 case that actually addressed this specific issue. And the point was raised there, same point. There was a condemnation and there was an argument that, well, look, this land is under lease. And the trial court made an error because it had judged us responsible for the entire value. And it didn't reduce it by the fact that the minerals under the ground were under lease. And the Court of Appeals says, no, the owner lessor is entitled to the full value. If the lessees, if the land is actually under lease, then that's between the lessee and the lessor. The lessee can seek compensation for the value taken from the lessor, but the lessor, the owner, actual original owner of the land, is entitled to full damages for the taking.
None of these leases that you're talking about are in the record though?
No, not one lease, alleged lease from the landowners to whoever their
And
lessee.
the only way this came up at the trial court was testimony that it was land that was abutted to this disputed area.
That the
was
land abutting the disputed area was under lease.
Okay.
I want to turn, unless the court has any further questions on the 6582 dichotomy, I do want to turn to the limit.
I do have one follow-up question on that. The state said, you made a comment, they didn't know at the time how much each landowner actually owned. Is that referring to what happened at the summary judgment level versus what happened at trial? Like at the summary judgment level, they didn't know how much each landowner actually owned.
Well, I'm speculating a little bit about what the state's argument, what they meant. There's no question that the position of the landowners was that they owned the land in those sections to wherever the midpoint was of the alleged riverbed, because there was no riverbed. I think what the state's argument is, they did not know what was owned because the mineral interest portion of that land, the mineral acreage, was not determined until we did a stipulation prior to trial. Candidly, I don't think it matters for a couple of reasons. They made the argument in the context of limitations. Well, in order to show that each landowner owned less than the 160 limit that caps the 10-year adverse possession statute, they're trying to show that it was actually under the 160 acres. The problem with that argument, number one, is it was never made to the trial court before this summary judgment hearing. The issue was never raised. There was no evidence submitted to the trial court for that summary judgment. It didn't come into play until the damages calculation at trial. And as this court knows, I believe it's ruled on at least 2 occasions that in order for the issue to be reviewed on whether a summary judgment was accurately granted, it has to have been raised and the evidence has to have been submitted before the hearing.
Well, one of the issues we're looking at is what the definition of the statute means. That seems to be an independent duty on our part that doesn't necessarily require preservation, right?
I mean, forgive me, Your Honor, for clarification.
So with regard to whether the 10-year period applies or whether the 25-year period applies, the fact that the parties didn't brief it, that doesn't mean that we're constrained by saying we're not going to apply the law correctly because nobody briefed it correctly.
Absolutely. I agree with it. That would be a question of law that would, I guess my point is this: there was no evidence submitted for the trial court as to the amount of acreage that it was allegedly under the 160 acres. And of course, our position on that point, and admittedly, I have searched the law and found nothing directly on point. But when you look at the adverse possession statutes and you look at the cases that apply those adverse possession statutes, everything is looked at from the point of view of the taker. Did the taker have a deed? Did the taker have a title instrument? Was his possession open and notorious? The state wants to say, well, now, okay, maybe you look at all that stuff from the viewpoint of the taker. But when you're looking at that 160 acre position, you got to flip it and look at it from the position of the landowner. And I don't believe that makes sense with respect to the adverse possession statute.
This was decided in summary judgment, correct?
Yes, Your Honor.
And was it your motion or your client's motion for summary judgment?
Yes, Your Honor.
And would the burden have been to show that the 10 years doesn't apply?
Yes, Your Honor.
So would that have been your burden to show that the 160 acres somehow frees your client from the limitations of the tenure?
Yes, sir.
And
And
how did you show that?
because again, our position is you look at it from the position of the taker. And it's proved that it was over 160 acre. We submitted evidence of what was taken.
Well, is the 160 acres based on claimants, or is it you pull a bunch of claimants and say we can total all of it? And that is the amount that is applicable for the limitations of period, not the individual acreage owned by the claimants.
Again,
Individual claimants.
forgive me, Your Honor.
No.
No, again, the position of the plaintiffs in the movement was simply this. You look at it from the position of the taker, which is the state. And what the state is taking is reflected in the Shine survey. I mean, there's no question now. I mean, we fought this case for 30 years under the notion from the state that that was riverbed. It was the position that they took really up until the time of trial. And finally, they concede, okay, it's not riverbed. We acknowledge that. In fact, I think here in this court, they're no longer taking the position that the Shine survey reflects what is riverbed. But they took that position for decades, even after this case was filed. And so they're claiming that they took the 1,700 acres in the Shine survey. And if you look at it from the position of the taker, it's well above the 160 acre minimum, or I should say maximum under the 10-year statute.
With regard to the 25 years, the statute was changed in the 80s. Which statute applies the pre-change or the post-change?
I'm going on memory here, but I believe the change occurred after the 1982 taking, which would mean that
That's right.
so I believe that the statute that was in place at the time the taking would apply. Not if it was changed afterwards. I don't believe that a change after 1982 would affect the analysis.
I was trying to determine, they talk about limitations being remedial and whether remedial is retroactive or prospective. And that's what I was trying to figure out. Would it be just prospective? It just applied future claims or going back? But you're saying at the time of taking, that's the limitations.
I mean, my understanding of the law generally is that you apply the law at the time of the act. And if the act occurred in 1982, then I believe the law in place in 1982 would apply. But you raise a good point. If the adverse possession wouldn't be effective until after, is that the one that would be?
Is there a difference in the statutes?
I'm sorry.
The difference in the statutes. I was reading from what I guess was the post statute. Did the pre-statute refer to some evidence of title owned by the person taking?
I believe the only thing that I believe what it refers to is an instrument.
An instrument.
And the reason and that is
the statute I mentioned. That verbiage is not in the original, other than just the pre-change just refers to an instrument. It doesn't refer to an instrument purporting to convey the property or a deed.
No, I believe it may refer to an instrument purporting to convey the property.
And that would be vis-a-vis the state. They took under an instrument purporting to convey property. What is that instrument?
I believe that I believe the instrument it refers to is the Shine survey.
Purporting to convey property.
Well, and I think this is important to read this in context with the other statutes. The other statutes, like the 3, the 5, and the 10-year, refer to both deeds and title instruments. This just refers to an instrument purporting to convey.
How does a survey purport to convey property?
Because again, if it's purporting to say, here's the gradient boundary, and the gradient boundary creates a riverbed that by the Constitution is owned by the state.
Why doesn't a survey just determine boundary as opposed to ownership?
I think in the circumstance when that boundary that it determines means it's owned by the state, that it necessarily is determining ownership. I mean, the flip side of it is if the survey came back and showed there is no riverbed, where it's non-navigable, then would you need a deed or another instrument to show it was owned by the landowners? I mean, the survey itself, under the Constitution, determines ownership. And so in this case, it's not a title instrument. There's nothing in it purports to convey title, but its effect under the Constitution is it does determine ownership.
What was the stipulation you mentioned at trial and how much each landowner owned?
There were a few stipulations that were entered. There was a stipulation as to, and I'm gonna ask my co-counsel or my opposing counsel to correct me if I'm wrong on this, but there were a few. One determined the entire ownership within each tract by land acreage, and the other another determined the mineral percentage under each tract for each landowner, if that makes sense. Those were the two, I believe, that actually affected ownership of property.
There wasn't one that said plot A landowner owns certain amount of acreage.
No, yeah, yes, there was. Very quickly, I have 2 minutes. I want to talk about the damages. In the state of Texas, there's two principles that we believe were violated by the court's judgment. The first one is that you determine damages at the time of the wrong, here at the time of the taking. The other one is with respect to condemnations. You look at the amount of damages that should be determined, not from the standpoint of the taker, but from just the standpoint of what was the value of what was taken. We believe the trial court violated that in two different regards. One, he determined damages based upon the royalties that were paid over 20, 30 years. That is by definition a calculation of damages that is post time of the taking. It is a calculation of damages that's merely adding production over a 30-year time period.
Can I ask you a question similar to that? We've got a taking during a 20 or 30-year period. The landowners who are your clients were not the owners of the property at that time, right? During the 20 and 30-year period of time when the minerals were actually taken, your clients didn't have ownership interests in the land at that time.
Well, we believe they had an ownership interest that was taken by the state in 1982. I mean, from 1982 on, they certainly.
Let me ask it a different way. If minerals were harvested in 1982, but you've got a plaintiff who doesn't come on the scene to own part of the land until 2017, how is that person injured?
I see what you're asking. We cited the court very quickly to the Vial case. And the cases that the state relies upon to say, look, if there's a subsequent purchaser, if it's not the same owner, those cases that they use are cases where there's a sale. And when there's a sale of the property post-act, then the damages are kind of baked into the sale price. Vial says differently. If it is a descendant or an heir, you do receive the right to sue. And the evidence in this case, in fact, it was Rod Wetzel's report that I believe is Plaintiff's Exhibit 49, which was the state's expert, went through all the ownership and showed that our clients were all heirs. And when there is an heir, you don't go through that analysis because they're not subsequent purchasers. Heirs had the right to sue. Heirs receive under inheritance the rights, any rights arising from damage to real property. And Vial in turn cited a Texas Supreme Court case in support. I believe it was the Dowd case, which all support our notion that because we're not subsequent purchasers, we're heirs, we have the right to sue. My time is up. Do you have any? If you have any further questions?
Council.
Thank you, Your Honor.
Roberto?
Thank you, Your Honors. Let me clean up a few points first. Justice Doss, I believe you asked the question, were the state's leases recorded? And I did not know the answer. Mr. Slavin has informed me they were recorded, both at the county and then they were filed with the state as well. There was an issue raised about whether there was drilling. Actually, let me back up and answer a different question for you first. Defendant's Exhibit 12. Again, I'm not by any means expecting you to read this, but the question was, how do you know what each plaintiff's mineral acres were in terms of mineral interest claimed? Those are from the stipulations, but then what Defendant's Exhibit 12 does is it takes each plaintiff, and for example, the first one is Richard Kuhn. He claimed mineral interest in 9 different tracts, and there's a column that gives you the total net mineral interest in each tract, and then it's totaled. There's a line, the last line for Mr. Kuhn is, it says Richard Kuhn Jr. T, then there's a blue number, and that adds up all the minerals, and that's where you can get the amount of mineral interest that each plaintiff is claiming. And here, the highest one is just under 100 acres, and then they drop down from there.
You don't look at the entire taking, you look at it per claimant.
Yes, I don't know how you could do it other than that, because you could have so many different facts and whether parties brought claims or not. And imagine, for example, if you just go to a regular takings claim, say the state's going to acquire some property for a freeway. Say the state buys some of the land, but then takes other property, and maybe 10 years later takes other property to continue the freeway. What period are you looking at? I just think the only way to do that reasonably is to look at each individual's amount of land being taken.
The exhibit you just referred to, I think it's 12.
Yes, Your Honor.
Was that a trial exhibit? Was that a summary
Yes.
judgment exhibit?
No, it's a trial exhibit.
Does it affect the fact that the trial court had already found adversely against you on that summary judgment before the exhibit came in?
No, and I'll tell you the reason why is because, again, I think it's correct that, number one, it's a question of law. What's the correct limitations period for this judge, no matter what happened? But secondly, the plaintiffs had the burden. It was their motion for summary judgment. They put on no evidence of the amount of acreage of their claim. So that would have been a burden on them. And then the third issue is there were only a handful of plaintiffs who were involved at that time in the summary judgment. All of the other plaintiffs' claims were resolved at trial on the limitations issue.
At summary judgment stage, they argue that with about a 10-year, no, that doesn't apply because you got to look at the entire taking as opposed to individual.
Yeah, I just think that's wrong. I think that's a
They
question.
argue that though.
Honestly, I don't know if they argued that at the hearing. I don't know the answer to that.
Okay, with
That
regard
way
to-
preceded my involvement
With
in the
regard
case.
to their survey,
I don't actually, Your Honor, I don't believe from looking at the motions, I don't think there was no one addressed the issue of the size of the claim. I think honestly.
with regard to a survey, opposing counsel argued that the survey is tantamount to an instrument of conveyance or something
Right.
similar to that. What's your?
I don't believe that's correct.
Why?
I think for exactly the reasons you said, all a survey does is determine boundaries, and it frankly may determine those correctly or incorrectly. I don't think that is in any way a conveyance of title to anything. The title
Is it not
whatever
different
is.
for the state though in this scenario?
I'm sorry.
Is it not different in this scenario because we have a provision that says if it's navigable water belongs to the state. So then we have a survey that says, hey, the boundary is here. This is where the river is. So then it just does become to you. So is it not
No,
different for the state?
I do think it's different because even with the state can make mistakes. The state hires a surveyor who makes a mistake. It's a mistake, but it's not a conveyance. The conveyance is still whatever the boundaries of the river are, whatever the law is, which is the gradient boundaries. Here, the sign survey, Shine made a mistake. The state also participated in that mistake. They didn't know the difference. At the time, people thought that when the Sanford Dam was completed, it was an evulsive event, they thought, which means it fixed the boundaries of the river. That turned out to be incorrect. The Supreme Court decided that and said, no, it's not an evulsive event. So you still look at the gradient boundaries, in which case the gradient boundaries shrink to nothing because they don't exist. You go to the center line. It's just a mistake that people made.
I have a question about your reading of Brazos.
Yes, sir.
So it's your argument that Brazos says, hey, it's a 10-year statute of limitations, but we don't actually look to the statute of the adverse possession statute. Like we don't look to the language of it even. I mean, so the 160 acreage argument is outside of Brazos. Brazos says it's a 10 years for takings. Or
Yeah,
should
I
we
think-
look to the statute?
No, I think Brazos simply says we don't have a limitations period for a takings claim. We have to find one. And I think at the time, some people were arguing it should be you should follow the general limitation statute, which was a 2-year statute. And the Supreme Court saying, no, we're not going to do that. We're going to borrow it from somewhere else. And we're going to borrow it from, and they said we're going to borrow from section I don't know if it was section 16.026 at the time, it probably wasn't, but in the Texas Civil Practice Rules Code, we're gonna borrow that 10-year limitations from an adverse possession claim.
They borrow all the portions of that
Yeah.
statutory.
We don't
provision,
know.
Or just.
Right, that's what my
Yeah.
question.
We don't know the answer to that. And none of the cases that have followed it have really literally delved into this issue. They have all just said, we're going to apply the 10-year, we're going to borrow it, and we're going to say 10 years is limitations for takings. I think that's the appropriate public policy thing to do, because you can imagine the myriad of problems that would come up if you dove into, are we going to apply each adverse possession, and adverse possessions don't clearly map over onto limitation, over to a takings claim. But those are issues that have not squarely been addressed by any court. I will certainly acknowledge that.
Council, your
my
time is
time up?
expiring.
Thank you, Your
Thank you,
Honors.
council. The case is submitted and you are free to go. Again, thank you for traveling to Amarillo, and I'm glad you got here on a day of good weather and safe travels home.
Thank you.
We will be in the brief